Court is back in session in New York this morning in the civil rape and defamation trial against Donald Trump. And just hours before court reconvened, attorneys for the former president filed a new request for a mistrial, zeroing in on the judge and making accusations of, quote, pervasive, unfair and prejudicial rulings by the court in this case. This as accuser E. Jean Carroll is back on the stand today for a third day of testimony. NBC News correspondent Ron Allen is outside the courthouse here in New York, and here in the studio with me is NBC News legal analyst Denny Savalos. Ron, tell us about this defense motion today and what exactly Tacopina is claiming and what we're going to expect in court.
He's claiming that the judge has been biased in favor of E. Jean Carroll and that he has not been able to question her as aggressively as he would like. He raises a number of issues where the judge has ruled that he couldn't go further or sustained objections, basically trying to say that the judge is favoring her and not allowing him to do what he wants to do. Not a big surprise that the judge denied this motion the minute court began this morning. Essentially, Donald Trump's attorneys were asking the judge to be very critical of himself, and that's very unlikely to ever happen in a court. So I think many legal observers would tell you that this is perhaps setting up a basis for appeal if the case gets that far. So cross-examination has continued this morning, and Mr. Tacopina had indicated that he was about halfway through when court concluded on Thursday, the last day. So we're expecting this to go on for several hours more today and then redirect. So she will probably spend her third full day on the witness stand going back and forth. And the questioning now is about her journal entries, about Facebook posts that she's made, about aspects of her column. Early on in the questioning, Tacopina tried to establish that she has returned to Bergdorf Goodman, the store that where this alleged incident happened, on a number of occasions, as many as 23 different occasions in the years since that alleged incident happened, trying to show the jury that she would do something like that. Again, trying to find inconsistencies in her story about what happened, and their central theme being that what she is saying is simply unbelievable. Anna?
Ron Allen, thank you so much for that update. Danny, what do you make of this new defense motion today? I'm just going to quote what they said. Pervasive, unfair, and prejudicial rulings by the court. That is why they want a mistrial declared. What do you make of it?
It was never going to be granted. The defense knew it was never going to be granted. And of course, the judge did not grant it. The judge denied it. And the reason I say the defense knew it wasn't going to be granted is that they knew that a mistrial is not going to happen in a case like this. So this motion served a different purpose. Actually, it served several purposes. Number one, it's kind of a press release about the woes and complaints and the way the judge is treating the defense in this case. It also serves to say to the judge, and this might work. You see in sports sometimes, right? If a referee makes a bad call, sometimes we think subconsciously, and you're an athlete, that the ref may maybe change, some calls and even things out in favor of both sides. Maybe it has that effect, maybe not. But most importantly, this motion serves to save the record in case of an appeal. If this case goes for the plaintiff and it goes up on appeal, these issues are preserved. Defense never expected the judge to grant it. They were basically complaining to the trial judge about the trial judge. Those are motions that are not likely to succeed. Yeah. But if nothing else, they've memorialized their complaints, and an appellate court can look at it if necessary.
I know my initial thought was, how often does blaming the judge in the case work in your favor? But it sounds like sometimes it can work moving forward, though, in the appellate process. This comes as we expect E. Jean Carroll back on the stand today. And after that very, very charged testimony we saw the last time she was on the stand, where we saw Joe Tacopina aggressively questioning her. Why didn't she scream if this actually happened during that attack? And so she was forced to respond to that. She got emotional. He's taken a lot of criticism. The defense lawyers have taken a lot of criticism for that kind of tactic. Do you expect a different tone today in the cross-examination?
No, this is Joe Tacopina. This is what made him successful. It's his style. He's confrontational. It's probably why Trump likes him so much and has him now as his attorney, not just in this case, but put in the New York criminal case. Here's the thing. On the one hand, a defense attorney has to explore the credibility of a witness, and it is really difficult in any kind of sexual assault case. But you have to explore things like motive, whether or not it's fabricated, the ability to remember what happened accurately decades ago. These are all fair game, but you have to do it very carefully in a civil manner, or else it can come off really badly with the jury. Tacopina here is taking a chance that he can paint this plaintiff as a liar. It might work. We have no idea until the verdict comes out, but it is a risky move to take her on like that.
We'll see what happens today. Danny Cevallos, thank you so much.